Ladies and gentlemen, welcome aboard the Wright Flyer. Today's flight is piloted by Randy Wright, who is joined by his first officer Jeremy Grapinten. We know you have a choice when it comes to your radio listening pleasure, and would like to thank you for choosing to fly with the Wright Flyer. Ground traffic control has moved us to the departure lane, so please be seated, fasten your seatbelts, and ensure that all tray tables are stowed in the upright and locked position. We will be taking off shortly, and once again, we'd like to thank you for choosing to fly the Wright Flyer. Now sit back, relax, and enjoy the show as we soar above the friendly airwaves in comfort and style.
Ladies and gentlemen, welcome aboard a special edition of the Wright Flyer. As I am sure you have all noticed, we here at the Wright Flyer adhere to a fundamental principle, namely that America is best served when her people possess a working and fluent understanding of the United States Constitution. In order to facilitate this process, we have decided to air a series of episodes devoted exclusively to the Constitution. Today's episode focuses upon one of the lesser-known aspects of the Constitution, the Preamble to the Bill of Rights. The Preamble to the Bill of Rights receives very little fanfare. This is because most courses regarding American civics and government, as well as constitutional law, do not include the Preamble to the Bill of Rights in the comprehensive study of the United States Constitution. Many in America aren't even aware of its existence. Nevertheless, the Preamble to the Bill of Rights is an integral part of the United States Constitution. It establishes in detail the scope and application of the Bill of Rights and explains why the Founding Fathers felt it necessary to adopt it in the first place. To ascertain a full understanding of the logic and reasoning behind the Bill of Rights, and indeed the Constitution itself, it is important to explain why the Constitution was ratified. On November 15, 1777, the Continental Congress established the Articles of Confederation. This unique document served as the first constitution of what would become the United States of America. Delegates from the 13 colonies and later states proposed the Articles of Confederation out of a need for, quote, a plan of confederacy for securing the freedom, sovereignty, and independence of the United States, close quote. From the outset, then, we can see that the Articles of Confederation established the natural law principle of sovereignty resting in the hands of the people, to be delegated to the central government. The Union was seen as a voluntary organization to foster cooperation and unity between the 13 separate states. What's more, it displayed the inherent mistrust of the Founding Fathers with respect to consolidation of power in the hands of a centralized authority. Therefore, it is plain to see from the Articles of Confederation the key and core principles of the United States Constitution were already firmly established as early as 1777. Nonetheless, the Articles of Confederation was a flawed document. It did not give enough power to the central government to ensure the protection of the 13 states. One of the problems was that the central government lacked the authority to lay and levy taxes. Therefore, it was all but impossible to raise a standing military. This inherent weakness was first recognized in the immediate aftermath of Shays' Whiskey Rebellion and the other whiskey rebellions which arose in the immediate aftermath of the American Revolution. Consequently, the Continental Congress convened the Philadelphia Convention in 1787. A few months after Shays' Whiskey Rebellion. And from that convention we were given the Constitution of the United States. The Constitutional Convention created a lot of debate. Two major factions, the Federalists and Anti-Federalists, debated the need for a written protection of the unalienable rights held by every American citizen. The fear at the time was, mainly, that eventually the federal government would begin to encroach upon the fundamental rights of the citizenry. Therefore, In December of 1791, the Bill of Rights to the United States Constitution was ratified. Included in this ratification was a preamble to the Bill of Rights. Thus, the United States Constitution contains two preambles. The first preamble is the preamble to the Constitution itself, while the second is the preamble to the Bill of Rights.
With the Bill of Rights being proposed to Congress, it was actually 12 of them proposed. Two of which dealt with compensation for congressional pay, and then, of course, congressional representation. Now, they were actually transmitted to the state legislatures, all 12 amendments or articles, on September 25th, 1789. Prior to that, it was the Congress of the United States, which was actually held in the city of New York, was on the 4th of March in 1789. So there was, from March of 1789 to September of 1789, they were working on these 12 articles. George Mason, Thomas Jefferson, and a few select other founding fathers actually got together and came up with what was ultimately derived from Virginia's state constitution. Now, when they introduced these articles, and once they were ratified, that's when the preamble came about, because when they were introduced, they got the solidity of the 10 Bill of Rights, so they had to have a way to introduce it or make it attached to the Constitution. That's where the preamble of the Bill of Rights comes in. The preamble simply states, the conventions of the number of the states, having at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. Resolved by the Senate and House of Representatives of the United States of America in Congress assembled, 2/3 of both houses concurring, that the following articles be proposed to the legislatures of the several states as amendments to the Constitution of the United States, all or any of which articles, when ratified by 3/4 of said legislatures, to be valid to all intents and purposes as part of the said Constitution, namely, articles in addition to and amendment of the Constitution of the United States of America proposed by Congress and ratified by the legislatures of the several states pursuant to the 5th article of the original Constitution. That first section there, that first clause, exemplifies exactly what Randy was talking about with the need, the discussions and the debates between the Federalists and Anti-Federalists. It carried on, even from the Constitutional Convention all the way up to this point. It was always carried on, and it was never really squashed until the ratification of the amendments. And even to this day, there's been talk of ratifying new amendments to the Constitution, so on and so forth. So there's always been a debate about things being added to the Constitution, amendments and being ratified, articles being changed, and so on and so forth. But the key part of this preamble is, one of the key parts anyways, refers to the articles in addition to an amendment of the Constitution carrying the full weight and to be valid to all intents and purposes of the Constitution, placing them under the auspice of holding the supreme law of the land, which is what the Constitution is, as per Article 6, Clause 2. So anytime there's an amendment ratified to the Constitution, the most recent one was actually 1992, which is the 27th Amendment that dealt with congressional pay. That was one of the first original 12 articles that was not ratified to the Constitution, but later, again, in 1992, it was. So when that happened, it actually became full force and effect of the Constitution as having the supreme law of the land. So when we have this preamble, it establishes, it ordains, and solidifies, and even expands the understanding of having a limited government, some would even make the notion that not only are the Bill of Rights are enumerated rights, it shows us and tells us exactly what authorities we the people have, but in a way it's also another set of prohibitions on the federal government and on the states, to where they are expressly told what they cannot violate. We have prohibitions in Article 1, Section 8 pertaining to the federal or Article 1, Section 9, pertaining to the federal government. Article 1, Section 8 is what they can do. Article 1, Section 9 is what they cannot do. And Article 1, Section 10 is delegated specifically to the states on what their prohibitions are. So the Bill of Rights and any and all amendments after that specifically show and point out what our rights are as American citizens, and by retrospect shows exactly what prohibitions, how those are actually spelled out in further detail.
Yes, and when looking at the opening paragraph to the preamble to the Bill of Rights, the scope and purpose of the Bill of Rights themselves becomes abundantly clear. First and foremost, it establishes that many of the state conventions expressed a desire to prevent the misconstruction or abuse of the federal power. Looking back at the Articles of Confederation, it was evident that the Articles lacked enough authority to act in the best interests of the several states. Despite this, the delegates feared that the federal government might usurp the proper scope and authority of the co-sovereign states, thereby oppressing the people, by whose authority the Bill of Rights were drafted and to be ratified. It also detailed the debate that had raged between the Federalists and Anti-Federalists during the Constitutional Convention, as Jeremy was speaking to. The Federalists were concerned that reducing a number of our fundamental rights to writing might lead the federal government to misconstrue the Bill of Rights as being an exclusive list of rights possessed by the American citizens. Therefore, great caution was taken to ensure that declaratory and restrictive clauses might be added as necessary. So, in other words, yes, the Bill of Rights contains all of the rights in it, but it can be added to. This is where people come up with that mistaken notion that the Constitution is a living document. No, it is not a living document, but the amendment process is. And those declaratory statements became part of the Constitution, as Jeremy had mentioned, and it is included to strengthen the public confidence in the fledgling government at that time, and of course not fledgling now, as well as its goodwill to act on behalf of the sovereigns, which again is reiterated as the American people. Thus, those declaratory and restrictive clauses also represented the embodiment of the anti-federalist desire to ensure that there was a concrete Bill of Rights, thereby protecting the people from the federal government by ensuring that it would not encroach upon the rights of the people. Of course, this reflected the concerns shared by both factions, that a powerful central authority could easily abuse its power. Thus, the Bill of Rights was a compromise to ensure that the proper scope and limitations of the federal government were reinforced in no uncertain terms. In fact, the preamble to the Bill of Rights is a clear reaffirmation of the core principles outlined within the United States Constitution itself. The second paragraph of the preamble states the resolved purpose and method of implementation of the Bill of Rights. It stated that both houses of Congress, via a 2/3 supermajority vote, drafted the Bill of Rights and submitted it to the several states for ratification. It further stated that the proposed articles would serve as amendments to the United States Constitution, and established that whenever such articles are ratified by 3/4 of the legislatures of the several states, they are valid as part of the United States Constitution. as Jeremy had mentioned. This is part of the constitutional process which can be said to be living, as I had said just a few minutes ago. It is available at any time, but requires strict adherence to the guidelines to ensure that the core principles of the United States Constitution are not detrimentally impacted by merely accepting those passing political fads.
I want to point something else out, too, going back to the declaratory and restrictive clauses. The notion behind the Constitution and the transformation that came about with it as to restructure the Articles of Confederation to make it a more perfect union of governance. The Founding Fathers and the framers of the Constitution, their whole intent was to set up a system of government that kept the government itself in check. Not only by the means of we the people holding the most power, but there was also restrictive and declaratory clauses that, in a way, in a minuscule way, also kept them in check. The provisions in here, with the way the preamble is written, it specifically states that it must follow the 5th article of the original Constitution, which is, of course, Article 5, the ratification process. That holds them in check. That prevents them from coming together as a tyrannical government and saying, no, we want to amend the Constitution for this so that government can have more control. It's a preventative measure from keeping the government limited, to keep them in check. Declaratory and restrictive clauses on themselves as well. That's why I mentioned the preamble of the Bill of Rights, with it giving all articles and amendments that are ratified to the Constitution, holding the power of the Constitution, all intents and purposes, as being the supreme law of the land. It prevents them from growing too big. It keeps them in check. It makes them beholden to a certain process in which only these articles and ratifications of amendments at any point in time must follow the Constitution. They have to follow that chain of command, that order. If they don't do that, and they're making amendments to the Constitution to increase their salary or to create legislation, or as we've seen with Supreme Court ruling after Supreme Court ruling, with them legislating from the bench, that is a direct violation of the Constitution. They're not going to take that legislation like the Affordable Care Act or Obamacare and ratify that as a constitutional amendment. They can't. They know they can't. This is why they're trying to skirt around the whole issue and delegate the authorities by themselves to each other without the consent of the people. This is a very dangerous thing. This is what causes governments to collapse. When you have 3 different bodies of government acting as a whole, 3 different branches, and they're just sharing the authority, liberally, and just spreading it around and allowing each other to usurp the authority from each other. It's almost as if they say, we don't care about the Constitution. We know the people have all the vast majority of authority, and they've delegated certain amounts to us. We want more. We're going to take more. The preamble to the Bill of Rights expressly prohibits that, because it forces them to hold to the ratification process of the 5th Amendment, or Article 5.
And to build on that, Jeremy, the 3rd and final paragraph to the preamble of the Bill of Rights announces that the amendments are in addition to the United States Constitution, once again reiterating the points you were making. In other words, that they were proposed by Congress and ratified by the state legislatures. It then expresses, as you have also just mentioned, that this power is enumerated pursuant to Article 5 of the United States Constitution. Therefore, I think because that article has been mentioned so much, it's imperative to understand exactly what Article 5 of the Constitution states. And it is this. To fully address this, I must recite the language. And the language is as follows. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to the proposing amendments, or rather to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by the convention in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate. As we can see, the preamble to the Bill of Rights reiterates the important application of the 2/3 majority requirement, and also reaffirms the 3/4 requirement of the several states in order to implement the amendments to the United States Constitution. It further delineates the power held by the several states and restricts the power of the federal government to act on its own. Thus, the entire process also reaffirms the notion of the enumerated powers and further states that amendments cannot be ratified in a way to restrict certain powers already enumerated to the legislature pursuant to Article 1, namely Article 1, Section 9, Clauses 1 and 4, prior to 1808. This was intended to prevent the new tenets of federalism from collapsing. And you were very point on with that, Jeremy, in stating that when you have these particular branches of government that are unaccountable, namely the judiciary, making this new law, it does undermine the entire structure of this federal government that they were building. And that can also be seen with the language stressing that state representation in the United States Senate could also not be redefined. They were attempting to keep power as close to the people as possible, and that's where the power has always been the strongest within this government, pursuant to the scope and application of the Constitution.
I want to bring up another point too, and we've touched on this ever so briefly before, but with the scope of the authority as it pertains to each individual article within the Constitution. You've mentioned before that, and we had this discussion on another episode, that Article 1 is lengthier. There's more substance to Article 1 as it deals to the legislative branch. And then you move to Article 2, which deals with the executive branch, which is even less verbiage in the Constitution, and followed up by Article 3, which is more or less even so. Article 5 is one clause. It's one clause that I believe, looking at it, encompasses, and going with this notion of each article being stepped down in its duration and substance. With each article stepping down, it's showing the true delegation of authority placed on each branch of government. And with Article 5 actually having even less substance, one paragraph, one clause, it encompasses all three branches, and it actually holds all three branches to that standard of how law and amendments, because when amendments are ratified to the Constitution, again, they are law. They become the supreme law. So that encompasses automatically all three branches of the government, legislative, judicial, and executive. It forces all three of them to equally adhere to the Constitution. And when people say we have three co-equal branches of government, that's where the equality comes, is within Article 5. All three of them are co-equally in the sense that they all have to adhere to the same structure of the 5th article of the Constitution. There's no deviation from that. All three of those branches. Because when we have amendments to the Constitution, sometimes and often they've been challenged in the Supreme Court. The court has to make a ruling. Yes, it's upheld, so on and so forth. States will challenge it, individuals will challenge it, so on and so, that's how it works. But this takes away all authority away from those three branches of government, and again places it at the helm of the people, squarely on their shoulders, because we the people are the ones who elect our state legislatures. We delegate the authority to them. We delegate the authority to our federal Congress. We hold the power. This is just it amplifies just what kind of power and authority the people have in this country. It holds them accountable. And when they step outside of that, again, going back to judicial review and legislating from the bench, or creating laws that are contrary to the Constitution, and delegating the judicial branch or the executive branch to act in such a way of either judicial review or legislating from the bench or operating with executive orders, so on and so forth, it removes the scope and applicability of the 5th article of the Constitution, thus depriving and abridging we the people our authority, usurping it from us. This is no different than what the King of England did, which brought about us declaring our independence from them and telling him, no, we are no longer under your rule. We are sovereign individuals and states.
Another aspect that we can take away from the preamble to the Bill of Rights, considered in conjunction with Article 5 of the Constitution, is that the notion that the Bill of Rights doesn't apply to the states was an erroneous one. And Jeremy, this is building off of what you were saying. In fact, the commonly accepted knowledge in the field of constitutional law is that the Bill of Rights did not apply to the several states until the adoption and ratification of Section 5 of the 14th Amendment, which states, "The Congress shall have power to enforce by appropriate legislation the provisions of this article." The very idea that the governments of the several states must ratify any amendment to the United States Constitution clearly demonstrates the natural applicability of the Bill of Rights to the states. Pursuant to the 10th Amendment, any powers which are not expressly delegated to the United States government are reserved to the several states and the people respectively. Thus, the mention of approval by the states demonstrates that the Bill of Rights was applicable to the states prior to the ratification of the post-Civil War amendments. However, the judiciary, via judicial review, as Jeremy has just mentioned, had determined that the Bill of Rights applied only to the federal government. Yet this is neither stated nor inferred from the language within the four corners of Article 5 or the Preamble to the Bill of Rights. Remember, in the first paragraph of the Preamble, it stated that one of the desires behind drafting the Bill of Rights was the prevention of misconstruction or abuse of governmental power and to strengthen public confidence in the government. Therefore, it's also extremely important to recall that the government, when capitalized as it was in the preamble to the Bill of Rights, included both the United States government as well as the governments of the several states. The Founding Fathers used capitalization for emphasis as well as to differentiate meanings where it could possibly be misunderstood.
I'd like to bring up the Ninth Amendment as well, because I think the Ninth Amendment actually pertains to this not so much in a loose manner, but in a way that people they don't really understand it. And again, we will touch on the Ninth Amendment and 10th Amendment and other amendments respectively in later shows, but I want to give a precursor to that, because the Ninth Amendment is one of the most often misunderstood and misrepresented amendment, Bill of Right, of all. It says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, using that in conjunction with the preamble to the Bill of Rights, when our rights, and with the 10th Amendment, it specifically speaks with powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. That right there confers our right of holding power. We the people, again, going back to the way that the Constitution is structured, with the length of each individual article decreasing in scope and substance from Article 1, 2, and 3, and then Article 4 and Article 5, it clearly substantiates that the people hold the most power and authority. We delegate our authority. We delegate the powers to the states, who in turn, like you've mentioned before, Randy, delegate some of that authority to the federal government. That's done so that the states are kept in check by the federal government and by the people, but ultimately both the state governments and the federal government are kept in check collectively by the people. So when they want to take judicial review and they want to attach it and make a ruling on, say, the 14th Amendment. The 14th Amendment, again, carries the full weight, full force and effect of the Constitution as being the supreme law of the land. When they take it and they twist it around and they construe it to mean something else, when they construe it to say, no, the Congress has the authority to do this and the Congress will allow this, this, and this. No, what they're doing is they are taking the authority, our delegated rights, under the 10th Amendment as holding the authority to delegate powers to the government. They're usurping that from the people. That is a blatant infringement upon our constitutional rights of having, which was actually established prior to the 10th Amendment, as in the preamble to the original preamble to the Constitution. We the people do ordain and establish this Constitution. It comes from us. Yes, it was framed by the Founding Fathers, who ultimately became presidents and congressmen and senators, but we put them there. They held those positions because we allowed them to. We delegated that authority to them to represent us. This is why we are a constitutionally representative republic, not a democracy, as so many people claim. People also say, well, we're a constitutional democracy. Can't happen. I don't buy that notion either. So when they take these things, and again, going back to the Ninth Amendment, they construe any portion or any part of any amendment or article to ultimately disparage or deny the rights of individuals, the rights enumerated in the Constitution. All of our rights are enumerated. There's no such thing as unenumerated rights. As Nelson Ward has mentioned on one of our previous episodes pertaining to the privileges and immunities clauses. When they have taken that right, they've construed it to mean something other than what's written in the Constitution, and they do it as an implied sense of usurping our authority. They themselves have no authority to even make law or even to hold those positions. So the Ninth Amendment is one of the most adamant and very key aspects of the Bill of Rights. It was written in such a way so that there was, again, this goes back to the checks and balances being placed on our legislators to hold themselves in check. Our founding fathers knew that absolute power corrupts absolutely. They set this in place to hold themselves accountable because it was their obligation to the people that they represent to do so. And it's gotten way out of hand. Our representative body no longer does that. There's no representation whatsoever.
And of course, that is the problem that we have been facing for quite a long while now. I think it is also of paramount importance to examine the last sentence in the first paragraph of the preamble to the Bill of Rights in depth, just to add to what Jeremy was saying. The idea of extending the ground of public confidence in the government, best ensuring the beneficent ends of its institution. That is such a remarkable statement. When you consider that most of the governments of that era were monarchies, where sovereignty was defined as a singular entity, the ruling monarch, this was quite a revolutionary shift in political thinking and philosophy. Our founding fathers believed wholeheartedly that sovereignty rested in the capable hands of the American people. Despite what revisionists may attempt to say, this ideal was meant to exemplify all American citizens. In the last sentence of the first paragraph of the preamble to the Bill of Rights, Congress was stating that without the confidence of the American people, or their consent thereto, the entire government would lack all credibility, as Jeremy was just saying. In other words, the United States is truly based off of a social contract, and that contract is the Constitution. It reiterates the importance of the people with respect to the proper scope and application of the government. When the government does not rule at the behest and consent of the people, then that government is no longer a valid government, as Jeremy has said. The Founding Fathers believed so strongly in this core principle that they included it in the preamble. Of course, this is reflected in two major amendments which aren't examined often either. Namely, the 3rd, 9th, and yes, I'm going to throw the 10th Amendment in there as well. While it may seem strange that I bring up the 3rd Amendment in this context, I do so for a very important reason. Tying it into the notion that the Bill of Rights applied to the several states, just as it did to the federal government. The quartering of troops must be understood in the context of the times. Remember, most armies raised for the defense of the homeland were comprised of state militias. Therefore, the prohibition of quartering troops in the homes of citizens would apply not only to the small corps of federal troops, but to the various militia groups that were called forth and given federal authority as well. This would have been the context in which the 3rd Amendment would have been understood at the time. Therefore, to claim that the Bill of Rights didn't initially apply to the several states as well as the federal government disregards this historical aspect of the Constitution. The 9th Amendment also expands upon this applicability. It is essentially connected to the same language contained within the first part of the first paragraph of the preamble to the Bill of Rights. Thus, the concerns of disparaging or misconstruing the rights of the people was reiterated in the form of an amendment. The 10th Amendment further explained the proper scope and application of the tenets of federalism, and it all shows that it points to any form of government that has delegated authority from the people. So that means the state government as well as the federal government.
You know, going back to what you were saying, as with the confidence in the government. See, back when the Constitution was written, the people, they didn't really have a whole lot of, they were leery. They were leery, yet some were naive, some were resistant to it, but ultimately, when it was all said and done, they embraced it. The confidence was there. The confidence was established because of the Constitution, because of the ratification of the Bill of Rights. because of the preamble. That confidence was strengthened and built in the American people, in the country. We don't have that now. What people are seeing is confidence with wanting to elect Jeb Bush or Marco Rubio, Ted Cruz, whoever the candidate may be. We've seen time after time that the American people, when it comes down to times of the elections, they've become so complacent. It's almost a sense of false confidence. It's non-existent. It's not even there. They don't understand what confidence is anymore. Many people will only cast their vote simply because of the letter next to the candidate's name, Republican or Democrat, doesn't matter. And the reason why they do this is something that we've touched on before, is political correctness, revisionist history, various different tenets and tentacles that we've talked about that's destroying this country, that is designed and purposely laid out as a flight path to destroy the Constitution. In order for the Constitution to be fully destroyed and completely done away with and absolved of holding any authority whatsoever, the confidence in the American people has to be destroyed and replaced with something else. That is what's happening. The confidence is being destroyed because people are not understanding the Constitution. They're not taking the time. They've become complacent. They've been told it doesn't matter. It's an antiquated document. It doesn't apply anymore. That being allowed to continue in this country is going to be our demise. It's not going to be a political party that destroys this country. It's not going to be an individual that sits in the White House as president. It's not going to be elected officials sitting in Congress. It's going to be we the people. Because when we are willing to compromise the sanctity of this, and we allow ourselves to be rid of any confidence in ourselves, it's confidence in the institution being what? The United States government. The United States government as the institution can only be built up and strengthened and adhered to if the people who established it, where the authority comes from, if we don't have confidence in ourselves in understanding the Constitution, knowing it, learning it, applying it, learning how to, as Nelson said before on the previous episode, learning to say no when the Constitution is being destroyed and our rights are being infringed upon. It's self-confidence is what it speaks to. When we throw away self-confidence, we lose all self-respect, all self-accountability. We become nothing but mindless robots, which is what we're seeing when people are voting for individuals just because of a letter next to their name. They don't care about the candidate's prior actions or voting record, what things they have done in order to maintain constitutional integrity of the country. When all of that's gone, we won't have a country. This is why we are doing this series. We don't want the American people to lose that confidence. We're here to help people regain that confidence, to help promote that confidence and advance it to where we can get back to the tenets of federalism, true tenets of federalism, true sovereignty of the individual. That is our aim and our structure here. That's what we want to do.
Right. And speaking to this confidence that you were speaking of, it's important to remember how long it took for the delegates to determine and draft the Preamble to the Bill of Rights, as well as the first 10 amendments to the United States Constitution. They first met on March 4th, 1789, to begin the deliberation process for drafting the Bill of Rights. It is also important to keep in mind that the delegates of the several states were not the actual state legislatures. Rather, they were special delegates elected by the people of the states to meet with the Continental Congress to determine the Bill of Rights. In the context of the timeline for the entire Constitution, you can see that this was 2 years after the first Constitutional Convention, and Virginia was the last state to ratify the Bill of Rights, including the Preamble, on December 15, 1791. Therefore, the entire constitutional process in the United States was a long and drawn-out one. But this was for good reason. The Founding Fathers wanted to ensure that the Constitution represented the needs of the people. Furthermore, they were concerned with ensuring that the sovereignty of the several states would not be encroached upon by a more powerful, centralized government. This is also clearly demonstrated by the exact language of the preamble to the Bill of Rights, particularly the reference to declaratory and restrictive clauses. That is to say, that the first 10 amendments to the United States Constitution, or the Bill of Rights, are a set of declaratory and restrictive clauses. In other words, they restrict the power of the federal government, as well as those of the several states, while superseding all other parts of the United States Constitution. Thus, the Constitution is clearly in the form of a contract. This is where we get the notion that the United States Constitution is a social contract with each and every citizen of the United States. Consequently, it is also clear to see that the United States Constitution was meant to limit the powers of the federal government. This is a fact which is not well received by the current political powers that be. That is because they do not wish to have their powers limited. As a result, the preamble to the Bill of Rights is not included in most publications of the United States Constitution. Nevertheless, it is undeniably a part of our shared Constitution, and I think that is another point that needs to be reiterated and harped upon. The fact that this is our Constitution. It belongs to us. It does not belong to those acting in government who are attempting to usurp its proper scope and application, to destroy, as Jeremy put it, the confidence of the American people in this system. Because what they want to replace it with is this tired Marxist doctrine that the government all of the sudden becomes this form of a religion. And it really is. It has all the pomp and circumstance of a religion. The Constitution was designed to prevent this. And to reiterate what Jeremy was saying earlier, I have to state that this is why we are explaining the Constitution, studying it together, because nobody can learn the Constitution perfectly. It is law. There is so much about it that just transcends time. That's why it is a timeless document. But we delve into this to gain a better understanding of the Constitution so that we are better equipped to protect ourselves from these attempts by those nefarious powers that would act in a tyrannical and despotic fashion so that we can defend ourselves against them. That is why this is so important.
You know, I want to ask all of our passengers or listeners a question, and I want them to think on this. And as they continue to listen, hopefully, should they choose to do so, to the rest of our upcoming series and future episodes on the Constitution, I want them to keep this question in mind. What is it about you? What is something in your life that gives you confidence? What helps motivate you? What makes you confident to carry on your daily activities? Your confidence in your job, or being a spouse, a family member, mother or father? What is your confidence of being a teacher, a police officer, whatever line of work you're in? Now I want you to think about this question too. What creates confidence in you as being an American citizen? I'll answer that second question. It should be the United States Constitution. As Randy said, and as Nelson has also said before, it is our Constitution. It's yours. It belongs to you. So if something belongs to you, there has to be something, when you have confidence, there has to be something that you possess to help build that confidence, to make that confidence stand strong. To have confidence as an American citizen, the Constitution is what does that for you. Not only just having the Constitution, not only knowing that it's yours, having a working understanding of it, that's going to build your confidence beyond measure. Everybody is going to be measured differently with their confidence. Everybody's understanding of the Constitution is going to be different. We understand that. We want to make this to where it could be understood to the best of your ability, and then you can take upon yourself part of being responsible and accountable for your own actions, delving into it yourself, picking up a copy of it and learning it, reading it. If you have any questions, find somebody who understands it. Go to an individual such as Randy or myself or our friend Nelson. Find that person in your life. Help them with understanding it. If there's things they don't understand, work off of each other. Because when you do that, when you look into this and you read it and you have a working understanding, that's where the confidence comes from. Just like with your confidence in being having a job, knowing your duties and responsibilities, your background, your skills and abilities, that's what builds your confidence. Knowing the Constitution and understanding that it's yours. With it being yours, you should understand it's kind of like owning a power tool. If you have an individual that owns a chainsaw, and if they have that, just because they have the chainsaw, they may feel confident that they can go out and lop off a couple of limbs from a tree or a bush or cut up some firewood. But if they don't have a complete working understanding of that chainsaw, their confidence level is only going to be at a certain degree. And when it's at a certain degree, they may mistake their confidence level to be overconfident, and that's when people get hurt. If you don't have a complete working understanding of the United States Constitution as being yours and being that entity that builds your confidence as a citizen, not understanding that is what allows us to be hurt. Spiritually, emotionally, sometimes physically. It has to be understood. You have to embrace it. You have to understand it.
Now, up until this point, we have examined most of the language of the Preamble to the Bill of Rights. Therefore, I'm going to shift the discussion to the purpose behind the Preamble. As previously stated, the Preamble to the Bill of Rights is there to state the intent of the people who founded the country. They were deliberately putting pen to paper in order to record their inherent distrust of centralized authority. This goes towards one of the inherent misconceptions about the Supremacy Clause in Article 6. Many political pundits today would have you believe that the federal government, and therefore all federal law, would supersede the governing authority of the governments of the several states. However, this would contradict the language of the 10th Amendment to the Constitution. Keeping in mind the thing that the Bill of Rights serve as declaratory and restrictive clauses upon the Constitution, even if Article 6 was to state that the powers of the several states are completely superseded by federal law, the 10th Amendment would override that aspect because the Bill of Rights supersede those parts which were previously included in the United States Constitution. Now, that's not to say that it takes out the application of the Supremacy Clause. Rather, it's to say when there is this conflict between the amendment and what was previously stated, the amendment will take control. That's like a contract, terms and conditions. It's really important to understand that I'm not saying that it erases this former part of it, but it supersedes it. And therefore, again, this is a reflection of the fact that the Constitution is that contract in its present form. And just to build on what I was saying, when addendums or amendments are made to a basic contract, they supersede the language previously included in the contract in question. So that if there's any confusion, the superseding language is what becomes precedent. Furthermore, such an interpretation, saying that the Supremacy Clause would always say that federal law trumps state law, contradicts the letter and spirit of the Constitution, as well as the delegates who gathered to debate, draft, and submit the Constitution for ratification by the several states. Indeed, by claiming that the federal law per se supersedes the laws of the several states, disregards the inherent tenets of federalism altogether. A complete dismissal of the relationship between the several states and the federal government disregards the entire credibility of the central government, which is what the first part of the preamble to the Bill of Rights was concerned with. When they were saying that these concerns had been brought up, that is what they were speaking to.
You know, I think using the 10th Amendment as the example there is tantamount to this. Again, powers not delegated to the United States government nor prohibited by it to the states are reserved to the states respectively and or to the people. Now, with the preamble specifically mentioning, again, that any and all articles or amendments ratified to the Constitution to serve as full intents and purposes of the Constitution, meaning the Supremacy Clause, simply put, it would state that if the Supremacy Clause, like you were mentioning, supersedes the having authority over the states, that would, by proxy, nullify the 10th Amendment as such as all amendments. So it would be contradictory of itself in order for that to happen. Because the 10th Amendment, as an addendum, so to speak, to this contract, it's written in such a way with the preamble that is the declaratory clause. The preamble in and of itself is a declaratory clause that attaches and binds the 10th Amendment as carrying out the full weight of the Supremacy Clause. So prohibits the federal government's authority from superseding the state's authority or the authority of the people. It melds the two together as one.
You're absolutely right. However, as we have mentioned before, this power that the Supreme Court handed itself with judicial review has been used in a completely detrimental fashion. The first Supreme Court case, which established the erroneous notion that the Bill of Rights does not bind the states, dates back to January 1st, 1833. In Barron v. City of Baltimore, a business owner sued the mayor and city council of Baltimore to recover damages for the partial destruction of the plaintiff's property on the wharf. There had been a particularly bad rainstorm which had swelled the water, causing the wharf to collapse. The court held that the provision of the Fifth Amendment, which limited eminent domain And this was going into some of the arguments that they were making, saying that it was a taking because they wouldn't pay for the damages. But anyway, the court was saying that the Fifth Amendment, limiting eminent domain, was meant only to apply to the federal government and does not restrict the governments of the several states from releasing themselves from it, saying that the states don't have to pay you when they take the property. But that's absolutely incorrect. But then we see in Lessee of Livingstone v. Moore, which was also decided in 1833. So that was a pivotal year for the court to really start this erroneous precedent that has basically fouled up the judiciary. The Supreme Court further stated that the Bill of Rights did not apply to the several states. The majority held, as to the amendments of the Constitution of the United States, they must be put out of the case, since it is now settled that those amendments do not extend to the states. However, in neither of these instances did the Supreme Court make reference to the preamble to the Bill of Rights. We must recall that the preamble to the Bill of Rights begins with the statement that the desire of the conventions of a number of the states wished to prevent misconstruction or abuse of governmental power. Keeping in mind that the tenets of federalism was the primary concern of those conventions and delegates, it would seem that they intended for this to apply to any form of government. Once again, I must point back to the specific capitalization of, quote, government, close quote, when they referenced extending the ground of public confidence in the government, that it was not intended as a limited application. We must recall that the authority of the federal government is derived from the powers delegated by the people. The governments of the several states are also an embodiment of representation from the people. Thus, the complete government must, by its nature, include the restrictive and declaratory clauses within its applicability.
And because the people delegate the authority to the states, and then the states delegate some of that authority to the federal government, it's cause and effect. To say that the states are removed from that, now if you were to remove the states from that equation, now you have the people and the federal government. There's no go-between. There's no checks and balances there. There's no lineage for which things are structured. It all comes down. At that point, if you remove the states, who's going to keep the government in check on behalf of the people? You remove the state governments from anything, even absolve them from being held accountable for transgressions. To do that, to remove them from that, it pits the people against the federal government, which is what we saw in England. You had the people and you had the crown. That is ultimately why we declared our independence, because the crown was so much more stronger than the people, until the people finally said, enough is enough. We hold ourselves to be sovereign. You can't rule over us in this fashion. It's not going to happen. Because we didn't have that intermediary. And now that the way our government is structured, we have that intermediary with the states. And the sole key of that intermediary is our individual state constitutions. All 50 of which must be in strict adherence to the United States Constitution in order to be valid. There's that stair step again. There's the chain of command. Ultimately, it comes from the people to the states to the government. Remove the states, you have the people against the government. What's stopping the government from saying, we're just going to go ahead and just completely do away with the Constitution. We're going to completely change it the way we want it to read. We no longer have to have the states' legislatures as per Article 5 of the Constitution to ratify it. Therefore, they would allow them to become a tyrannical regime of implementing amendments to the Constitution that strictly favor the government as opposed to being at the behest of the people, which ultimately delegate the authority to everybody.
Right. And that's absolutely why these Supreme Court cases that dealt with that have been so damaging. So now that we've reviewed the case law departure from the language of the Preamble to the Bill of Rights, it's very important to determine the original intent of the Founding Fathers. This intent can be found by examining the evolution of the Founders' approach to the federal government from the time of the Articles of Confederation to the proposal and ratification of the Bill of Rights. As was stated at the outset of this program, the Articles of Confederation had been drafted in such a way as to prevent the central government from laying and levying taxes. Thus, it is apparent that the Founding Fathers worried about the overarching authority of the central government. After all, one of the British claims was that the former colonies had full representation via Parliament in London. And this is going kind of to what Jeremy had just said about people being pitted directly against the government. And furthermore, one of the major causations of the revolution was taxation without representation. Again, government and people pitted directly against each other. Consequently, the Founding Fathers adhered to a strict belief that representation best rests with those governmental bodies closest to the people. Nevertheless, the debts accrued by the 13 states in their quest for independence was more than they could cover alone. Therefore, a more perfect union was necessary. Despite this necessity, the founders wished to adhere to the fundamental principles which motivated their drive for independence. This desire, and it is from this desire, to remain true to their heartfelt principles, arose the tenets of federalism. It is from that desire that we get the hierarchical structure that Jeremy and I have both mentioned. But what exactly is this doctrine of federalism? The answer is best found within the language of the foundational documents themselves. Of course, the preamble to the Bill of Rights mentions the concerns shared by a number of state delegates with respect to misinterpretation and encroachments upon the unalienable rights of the people. Thus, two particular constitutional amendments specifically address the relationship between the governments of the several states and the federal government, namely the 9th and 10th Amendments. Now, I know we've mentioned these amendments a lot, but they are so key and central to this. These two amendments established this relationship, which we know as the tenets of federalism. The 9th Amendment basically states that no right can be construed to disparage other rights, and that Congress cannot create or abridge the fundamental rights of the people. This is strengthened by the 10th Amendment, which states that any power not expressly delegated to the federal government is reserved to the states and the people respectively. In other words, full sovereignty, as we have stated time and again, rests with the people, who delegate certain authority to the states via their state constitutions. The states, in their representative capacity, in turn delegate certain authorities to the federal government as per the United States Constitution. It is this relationship of power which constitutes the tenets of federalism.
See, this, and I know I'm harping on this quite a bit, but it goes back to the people having an understanding of this. And again, this is why we're doing this. You know, we're not doing this because people are paying us to do this. We're not seeking payment to educate people on this so much. We're looking at this, our payment and such is that of what the Founding Fathers viewed when we broke away from England. It was building a government, a society, to where people could actually enjoy their freedoms. And that's all we want for other individuals, for our listeners, for everybody out there. We want you to understand what your freedoms are, what's at stake when you lose them, or when you don't exercise them, when you cast them aside because of complacency, because you don't understand the confidence that comes along with it. This is what our founders wanted. They wrote these documents, and I'm going to say this as far as so much as the United States Constitution, in my opinion, is probably the best document written by man. And when I say that, a lot of people may misunderstand me and say, "Oh no, the Bible's the best." No, the Bible was never written by man. It was dictated and notated by man. It was written by God. The United States Constitution was written by man with divine inspiration. Okay? Men came up with these ideas because they had a basic understanding of natural law. They understood the tenets of federalism, what it meant to be a sovereign individual, what it meant to have unalienable rights that were endowed to us by our Creator. To dismiss that and dismiss the Constitution, you're dismissing yourselves. And we don't want to see that happen. We don't want people to dismiss themselves. We want people to be confident in themselves, confident in knowing that their Constitution, your Constitution, is what allows you to remain free. Again, it's not a president, it's not an elected official, it's not your local dog catcher covering all scopes of elected officials in there. It's you. Your understanding, your working knowledge, and your confidence that you put the time in to build up with understanding the Constitution. I'd like to make some recommendations. We've talked about the Federalists and Anti-Federalists to get a better understanding of them. And take it from me, it is a dry read, but it's so important. Sometimes you have to endure things in order to come out on top. Get yourselves a copy of the Federalist Papers and Anti-Federalist Papers. Pick up a copy of the Constitution. Grab a copy of the Declaration of Independence. Anything you can get your hands on written by the Founding Fathers that will help you build your confidence up with this. Help you regain your confidence. Help you get a better understanding or regain the understanding that you may have once had regarding these issues.
And you know, Jeremy, this also speaks to the proper interpretation of Article 6, Section 2, or the Supremacy Clause. Since the time of FDR, this clause, in conjunction with the Commerce Clause of Article 1, Section 8, has been used to afford the federal government near absolute power. In Wickard v. Filburn, the United States Supreme Court held that the Commerce Clause granted Congress the authority to pass legislation which did not directly concern interstate commerce. Interstate commerce, of course, is the exchange or trade of goods between the several states. What's more, the Wickard case established the doctrine known as the Dormant Commerce Clause. The Dormant Commerce Clause essentially states that any activity which indirectly deals with interstate commerce may be regulated by Congress pursuant to the Commerce Clause in Article 1, Section 8. However, this is completely contrary to the letter and spirit of the Constitution. This can be seen within the preamble to the Bill of Rights, which stated that the Bill of Rights are declaratory and restrictive clauses. And that is, I keep harping back onto this because it is such an important part. And what this means is that even if this interpretation by the courts was proper, the Bill of Rights once again supersedes the Commerce Clause. Additionally, the Dormant Commerce Clause violates the Fifth Amendment right against unjustified taking of property, and the 10th Amendment's prohibition against encroaching upon state authority and the authority reserved to the people. But it doesn't stop there. The Dormant Commerce Clause also misconstrues the enumerated Commerce Clause power in such a way as to disparage the unalienable rights of the people in their pursuit of happiness. Thus, once again, via the self-proclaimed power of judicial review, the judiciary took it upon itself to legislate from the bench to the detriment of the people. With this doctrine, the federal government sought to free itself from the constraints of the Bill of Rights as it was meant to apply. And pursuant to the express language of the Bill of Rights, they are doing whatever they can to entrench their power and slowly take away more and more from the people. And again, this goes to what Jeremy and I have been saying from the outset, that we have to be vigilant in defending our rights, and the way to do that is to have a working and fluent understanding of the United States Constitution.
And I can't reiterate that enough. It's one of those things, and I myself actually fell victim to that. Um, you know, being at my age, I've voted in ways because I thought that was the right way to vote. I before I voted straight party ticket, not having a full understanding of who I was voting for, because I didn't have a full understanding of the Constitution. Now, I'm a firm believer that we all know what the Constitution is. We all know what it is. We all know what is inside the Constitution, what it entails, the scope of it. But knowing that and understanding it, that's where the difference is. I knew about my rights. I knew I had the freedom of speech. I knew I had the right to own property, the right to keep and bear arms, so on and so forth. The right to, legal counsel and representation, jury trial, so on and so forth. But having an understanding of how that's applied in certain circumstances, that's the key. And when you grab that key and you use it to unlock the door of having a better understanding and actually applying it by exercising your rights, becoming more, again, this is the confidence builder. When you exercise your rights and you do it over and over and you are not afraid to exercise your rights, your confidence level goes up. Thus, when your confidence level goes up, now you are more apt at looking at the individuals that you would be voting for, and you would hold them accountable because of their actions. You'll understand better what they're trying to convey to you. And then, with doing that, you'll be able to get a better understanding of who is actually better fit to represent you as an elected official. Because again, this is a constitutional representative republic. We can only expect the representation that we elect into office. Now, if we keep electing individuals into office that time and time again want to usurp your authority, usurp your rights, take them away from you, pass law that will violate your rights, at that point, where do you point? At who are you pointing the finger? If you're pointing one finger at them, you have to remember there's three fingers pointing back at you. If you're electing these individuals to do that, in a sense, when we do that, we have who to blame. Can't really blame them because you're putting them in a position that they've always wanted, so they're going to tell you that. So you can't blame them for doing what they've done to get elected. You can only blame ourselves for putting them into that position by delegating our authority to them to represent us. It's like that old saying goes, you get what you pay for. So I'd like to bring up the saying, buyer beware. Have a full understanding of what you're buying, so to speak. Know how it operates. Know what's entailed with it. Know what the consequences that are going to come with it. and again, remember, I want everybody to think about this question. What builds your confidence for you? What is it that you possess that is your confidence builder? And then apply that to, if being a United States citizen, what should be your confidence builder for you? Give you a hint again, United States Constitution.
That's absolutely right. And everything that we have said here tonight and on every other episode of the Wright Flyer that we have done is done so that you can gain that power to act for yourself. Because if you look at the tenets of our United States Constitution, this shared document of ours, the most important and critical aspect to understand about it is that it is designed so that each and every one of us can be self-accountable. The power rests with the people because the people are the purest form of sovereignty. And that's clearly what the Founding Fathers had intended with the Bill of Rights. And that is why we thought it so important to address the preamble to the Bill of Rights, even though it is not well taught, not well understood, not well known. If we continue to have these discussions, we can turn around this trend of lack of knowledge and slow loss of power by the people. And again, we also do this so that we dispel that myth that the United States is a democracy. As Jeremy and I have both reiterated numerous times, as our shared friend Nelson Ward has stated numerous times, it cannot be a democracy because that would take away all of the power of the people and allow a tyranny of the minority to take control. And I explain that in a little more detail in the solo episode or solo flight that I did earlier with respect to the separation of church and state and its true understanding. And that's why we're going to continue to do these constitutional special episodes, because it is absolutely imperative that we all gain a deeper, working, and fluent understanding of the United States Constitution. That said, it has come time for us to begin our descent. I'm sending the flight attendants back for one last round of alcohol. So folks, sit back, relax, and enjoy the descent. We will see you next time. I'm Randy Wright. This was also my first officer, Jeremy Grapington. Thank you again for choosing to fly the Wright Flyer.